So good morning, members. So today we'll be discussing about the Judicial Service Code of Conduct and Ethics. Remember, there is a session that we did a full analysis of the SOPEC rules from top to bottom. And this is also a very important document for CLE purposes. I tried as much as possible to stay relevant while analyzing the Code of Conduct for judges. So I'll first give you the overview of it from the table of content and what we are expecting. So we are expecting to hear from part number 2, we'll see various code of conduct and ethics for judges. We intend to see their independence, impartiality, private communication, integrity, responsibility for social media activities, accountability and prohibition against bribery and other corrupt practices, propriety, equality and non-discrimination, professionalism, involvement in other activities, commenting on matters pending in court, offers of future benefits, conflict of interest, recusal, public collections, participation in tenders, care of public property, bank accounts outside Kenya, gainful employment, tax, financial and legal obligations, bullying, prohibition against sexual harassment, acting through others, confidentiality, obtaining documents unlawfully, misleading the public and falsification of records. Then we will also see code of conduct and ethics for judicial officers. Now the first part 2 was on code of conduct and ethics for judges. This is for all judicial officers now, where the same concepts will be repeated. Okay, take a look at how they are being repeated. The same ethics, code of ethics, is being repeated for judicial officers. We also have code of conduct and ethics for members of judicial staff. Take a look at how the concepts are being borrowed, because each category is different. Then take a look on enforcement, oversight, and implementation of the code. So this will mark the first part. Then we will have to schedule another part of it where we'll have exhausted everything that the examiner can bring in such kind of a paper. And for purposes of time, this session will not be in a position to go every rule by rule in verbatim. But what we will see is that in every topic, I've tried as much as possible to create a problem scenario. And from this problem scenario, it will be testing various principles on that part of the code of conduct. Because a session where the code of conduct will be analyzed verbatim, it is proper to have that separate as compared to one where we have Q&A sessions. The answers will be gotten from this document. So in question number 1, it is testing on independence, private communication, and impartiality. We are told that Justice Amina is hearing a constitutional petition challenging a major government infrastructure project. The cabinet secretary responsible for the project telephones her privately and states that an adverse judgment will damage the economy and embarrass the president. He sends her confidential government reports that have been filed in court. Justice Amina reads the reports without informing the parties. A week later, the petitioner's advocates request a private meeting with the judge to explain technical matters in the petition. The judge meets the advocate in chambers without the respondent's counsel. During the hearing, she repeatedly praises the government's development record and tells the petitioner that courts should not frustrate elected leaders. Remember, the topic is independence, private communication, and impartiality. The questions. Identify the ethical and constitutional violations arising from the Cabinet Secretary's communication and Justice Amina's response. 8 marks. Was the private meeting with the petitioner's advocate proper? What should the judge have done upon receiving both communications? And C. Explain the appropriate remedies and accountability processes available to the parties and the JSC Commission. This is where I leave parties to be at liberty to try out any kind of a question that they think they have come across such code of ethics in relation to what we are being asked by the examiner. Because the question number 1 is on ethical and constitutional violations that are arising from the CS communication and Justice Amina's response. While you frame your answer, and was the private meeting proper? And what should the judge have done upon receiving both communications? Then, explain the appropriate remedies and accountability processes available to the parties and the JSC Commission. Do you have any clue of what is happening? Any member? Then we reveal the marking scheme.
In this case, I would look at the defense bungalow principles with regards to the judicial code of conduct that Justice Amina would be upsetting by privately having that meeting with the petitioner's advocate as well as the cabinet secretary. There's also the issue to do with separation of powers. But with regards to the ethical and constitutional violations, I'm going to look at the principle of judicial independence, and by allowing herself, that is justice, by allowing herself to be influenced and inappropriately by another arm of the government, that is now the executive in this case. This would interfere with her independence in deciding this matter. That is one of the violations or issues that would be arising. The judge would also have to be impartial because there is actual bias for having had these private meetings with a member of the executive, that is the CS, as well as the petitioner's advocate. So there is actual bias because she also has what's the word? Okay, I'm playing for it's okay. Let someone answer. But I have an idea of how to go about the question. I think I'm just exhausted.
Thank you, Madam Rosa. And because of how this session is lengthy, I'll be limiting one attempt per student so that once you have tried to answer the question, at least we can now appreciate that you have understood that kind of a question, because you cannot attempt that which you have not understood. So let us see the marking scheme because the session is a bit detailed. On independence and impartiality, question A. The Cabinet Secretary's communication is an improper attempt to influence the judicial process. Under Article 160 of the Constitution, the judiciary is subject only to the Constitution and the law and is not subject to the control or direction of any person or authority. Under Article 159(2), it requires judicial authority to be exercised according to constitutional principles, while Article 51 guarantees every person a fair and public hearing before an independent and impartial tribunal. Under Regulation 7A to E of this document, a judge must uphold judicial independence, maintain independence of mind, prevent interference, decide matters on evidence of law, and avoid extraneous influences, prejudice, and even bias. By reading material privately supplied by the seers and failing to disclose it, Justice Amina compromised both actual and apparent independence. Her comments praising the government and suggesting that courts should defer to elected leaders also raise reasonable apprehension of bias. They offend Regulation 9, which requires impartiality, objectivity, and freedom from favoritism, and Regulation 14, which requires avoidance of impropriety and its appearance. The CS attempt may also engage Article 73, which treats public authority as a public trust, and the Leadership and Integrity Act. Depending on the purpose and conduct, it may constitute improper interference with the administration of justice. So, what are the key takeaways in such an answer? You have been told to talk about independence and impartiality. So, you must exhaust the articles provided for in the Constitution on independence. And this is particular under Article 161 of the Constitution, where we can say the judiciary should exercise independence from any other arm or direction or any person or authority. And Article 159 too, that requires a JO to judicial authority to be exercised according to the constitutional principles, and even Article 51 to guarantee a person a fair right. And now, if you check the provisions of this document, if you read Regulation 7A to E, it is about a judge upholding judicial independence. And if you read Regulation 9 of the same document, it is about impartiality, objectivity, and freedom from favoritism. So a judge should not favor an individual so as to create an impartiality situation. Then if you read Regulation 14, it requires avoidance of impropriety and its appearance. In any way at no given time should impropriety be portrayed to the litigants. Now, we have private communications. There is a phone call that the judge is receiving. Under Regulation 10(1), a judge must not initiate, permit, or consider private communications relating to a pending or impending matter. The meeting with only one advocate was therefore improper. When a judge receives such communication, Regulation 10(2) requires the judge promptly to inform all other parties and retain a court record of the communication. Regulation 10(3) requires judges primarily to speak through their judgments and not correspond privately with litigants about pending or determined matters. Justice Amina should have refused both approaches, preserved the communications, disclosed them on the court record, supplied the material to the parties, and invited submissions. If the reports were relevant, they can only be received through lawful, evidential procedure with all parties afforded the opportunity to respond. She should then have considered recusal under Regulation 21. Okay. So key takeaways from this question is that if you read Regulation 10 of this document, we are told about a judge being in private communications in a matter that is still pending in court. And if you read also Regulation 10(2), we are told that the judge should promptly inform all other parties and retain a court record of the communication. And Regulation 10(3), the judges primarily to speak through their judgment. So the judge is advised to speak through the judgment as compared to privately speaking with litigants. And then consider a recusal under Regulation 21 where you are conflicted. Then question C required students to talk about remedies and accountability. A party may make a reasoned recusal application based on Regulation 21. The objective question is whether a reasonable, informed observer will apprehend the bias. Because the Supreme Court discussed the objective recusal test in Jasbir C. Rai versus Torchalai Sai Rai, while cautioning that recusal must not be used for judge shopping. So the Rai versus Rai decision is a very landmark decision when it comes to the objective question in recusal applications. And the test is that it should be reasonable, informed observer who will apprehend bias from the face of it. A party may also challenge any resulting decision on appeal or review for breach of Article 50 and reliance on undisclosed material. Any person may lodge a complaint under Regulation 78 using the procedure prescribed by GAC. Under Regulation 79, breach of the code constitutes a misconduct. Minor infractions may be handled administratively by the Chief Justice under Regulation 78. Serious misconduct, bias, or breach of the code may engage the constitutional process under Article 168 1B for removal of a judge. JSC's mandate arises under Article 172 1C. So those are the remedies and accountability measures that the parties can engage in, and even GSC can suo moto institute a misconduct claim against the judge. So the relevant provisions are Regulation 21 on recusal applications and Regulation 78 on bringing a complaint under JSC. That was a good opener. So I see the answer still continues. Justice Amani argues that the code is merely advisory because judicial independence prevents the JSC Commission from controlling a judge's conduct. A magistrate states that the code applies only to superior court judges. Okay, this is the second question. This is a second question. Yes, this is a second question apart from the first question. So this question asks us, Justice Amani argues that the code is barely advisory because JSC independence prevents the Judicial Service Commission from controlling a judge's conduct. And a magistrate states that the code applies only to superior court judges, while a legal researcher says it does not apply to interns or consultants. During a public lecture, Justice Amani knowingly gives inaccurate information concerning the judiciary's budget and uses a judiciary vehicle to attend a private commercial function. 1. Identify the persons to whom the code applies. B. Explain the objects and guiding principles of the code. And C. Analyze Justice Amani's conduct and explain whether judicial independence excludes ethical accountability. Now, how can you attempt one way or another in answering this question 2? Do you know the object and guiding principles of the code? Do you identify the persons to whom the code will apply? And can you analyze Justice Amani's conduct and explain whether judicial independence will exclude ethical accountabilities? Will the code of conduct apply to interns and consultants, or even magistrates, or is it applicable to judges only? It's very important to have that distinction. Yes, Madam Abigail?
Oh, thank you. I am aware that under Regulation 47 of the Judicial Service Code of Conduct, it also speaks to a judicial officer that recusal for judicial officer. So Regulation 21 normally speaks to a judge. It just speaks about the application you can make to or rather recusal in relation to a judge, but section Regulation 47 speaks about judicial officer. And for, I think if you look at the definition, uko juu, on who is a judicial officer, it says that, okay, sioni, but najua judicial officer can include a magistrate. So my answer would be it also applies you can make an application for recusal even against magistrates.
Thank you. Mr. Martin?
Emma, good morning. I think for the interpretation of what judicial officer is, this should be able to include even any staff working with the judiciary, whether on permanent or on a contractual basis. So remember, these are staff who are working with the JU. So I would imagine that whether you're a legal researcher or a staff attached to the judiciary, then this judicial service code of conduct should be able to apply to you. Just the same way, like the an advocate and his staff. The same, I mean, the same basically. So I think I'll use the interpretation provided at the section 2 to mean all the staff, whether the officer, research officers, I mean, and anybody who is on contract or permanent.
Thank you. Let me submit your answers against the marking scheme, because we are doing an indirect way of going through the regulations. The code applies to judges of superior courts, judicial officers, and judicial staff under Regulation 5. The definition of judicial staff in Regulation 2 is broad and includes permanent and contractual employees, legal researchers, consultants, seconded personnel, casual employees, interns, pupils, and persons undertaking attachments. The magistrate, researcher, intern, and consultants therefore fall within the code according to their respective capacities. Under Regulation 3, the Code gives effect to Article 168(1)(b) and 172(1)(c) of the Constitution, Article 10, the Leadership and Integrity Act, the Public Service Values and Principles Act, and the Public Officer Ethics Act. It states minimum standards, guides personal and official conduct, and provides a framework for regulating judicial conduct. Regulation 4 grounds the Code in judicial independence, accountability, public confidence, integrity, impartiality, equality, the administration of justice principles in Article 159, and the priority of judicial duties over personal activities. Judicial independence is not immunity from ethical accountability. Article 161 protects judicial decision-making from control or direction, but Articles 168 and 172 establish accountability mechanisms. The JSC must promote both independence and accountability under Article 172 and enforce Code of Conduct under Article 172(1)(c). Ethical oversight must not be used to punish a judge merely because a party or public authority disagrees with a lawful decision, but it may address misconduct independent of the merits of the decision. Justice Zamani's knowingly inaccurate statement contravenes Regulation 6C, requiring honest representation of information to the public, and potentially Regulation 33A, which prohibits knowingly false or misleading information. Use of the judiciary vehicle for a private commercial function may amount to imprudent or unauthorized use of public resources, contrary to Regulation 6E and the duty to preserve public property under Regulation 24. It also implicates Article 73(2)(b), which requires objectivity and impartiality, and Article 75, which prohibits conduct that compromises the dignity of a state office. Under Regulation 78, breach of the code amounts to misconduct and may trigger disciplinary proceedings. If you're in a position to hear about JSC interviews, there was a certain magistrate who was told by the commission that he was engaging a police station pickup to ferry goods from the court premises to his home, and it was alleged that he was seen by a litigant selling furnitures. Okay, so that kind of question invoked various principles of the Code of Ethics. One, we can say about using public property under Regulation 24 for your personal gains, and we can also say on Regulation 33A, which will prohibit you knowingly giving false or misleading information before the panels, because they have an insider information and they can even be having evidence against you. And we are told that under Regulation 79, breach of the code amounts to misconduct and may trigger disciplinary proceedings. If he could have admitted before the general public, that could have amounted to a direct admission of misconduct. And we saw the JSC people appearing to be well informed, because we were even told that on Fridays he was turning the court premises to a Nyamachoma and Mbuzi center, and he attempted to defend himself by saying that that was only one occasion, and there are people who are fighting him for his stand against corruption. That's why they are bringing the misconduct aspect when he is applying for JSC position. Now, the key takeaways in this part is that we have been able to see the various categories of people who are confined by Regulation 2 as part of the people in Regulation 5. So it is an extension of Regulation 5. Judges of the Superior Court, JOs being magistrates, etc., and judicial staff under Regulation 5. So even interns and pupils and persons undertaking attachments and even contractual employees will fall pursuant to Regulation 2, as Madam Abigail tried to tell us. So basically, all other provisions will be repetitive in nature, and before we finish up this kind of discussions, these regulations will have stuck at the back of your fingertip. Then we have question number 2, that is testing on judicial independence, impartiality, and ex parte communication. So if it is appearing to be testing that which we have discussed, we will directly see whether there is any exceptional question arising from that part, and then we can go to another part. So we are told that a cabinet secretary gives a telephone call to Justice Biko and urges him to issue an injunction in a politically sensitive dispute. Later, the counsel for one party sends the judge an encrypted message attaching helpful authorities and discussing the merits. Justice Biko reads the message, does not disclose it, and grants the injunction without referring to the communication. He later states that he independently reached the correct legal conclusion. Discuss the judge's obligations concerning institutional and decisional independence. Analyze the private communication and state the proper procedure after receiving it. And C. Explain whether the correctness of the ultimate order cures the ethical breaches and identify the possible remedies. So we are told that Justice Biko never revealed this information. He just reads it and grants the injunction without referring to the communication. He later states that he independently reached the correct legal conclusion. So in such kind of a situation, he has received an information, but is in judgment. He appears to not be making reference to the communication, but he read that message. Is that a point of concern when it comes to ethics against judges? Any direct answer, yes or no, then we see what the marking scheme is telling us. Any member? If I just read the message and I give a decision without making reference to the communication that you have sent to my private number, will that be amounting to the breach of the code of conduct? Okay, with the silent, I assume that question is difficult, and it is.
Please allow me to give a try.
Yes.
With regards to judicial independence, the judge is supposed to make the decision independently by analyzing the facts of the case and relying on the understanding of the law to reach the conclusion, and should not rely on another party's, like the encrypted message, and that would interfere with their independence of thought, and it would also cause bias So there's also an issue of lack of impartiality because they're being persuaded. Yeah.
So thank you, Madam Rosa. So to see if your answer, you're saying the answer is yes, that it will be amounting to the breach of code of conduct because it is persuading the judge in one way or another in making out his decision. So the answer to part A on discuss the judge's obligations concerning institutional and decisional independence, we are told under Regulation 7 that a judge must uphold judicial independence and the authority of the courts, maintain independence of mind, resist interference by persons and state organs, determine cases from facts and law, and avoid personal bias. So this gives effect to Article 159(1) and 160 of the Constitution. So Justice Biko should reject and document the Cabinet Secretary's attempt to influence the court and, where appropriate, report it to the Chief Justice, JSC, or competent investigative authority. So the Council's message is prohibited private communication about a pending matter under Regulation 10(1). A judge must not initiate, permit, or consider such communication. Under Regulation 10(2), if it is received, the judge must promptly inform the other parties and preserve a court record. Take a look at how the regulations have even stipulated a procedure of what to do when you receive a private communication. You don't merely ignore it. You promptly inform the other parties and preserve a court record. Under Regulation 10(3), a judge should primarily seek through judgment and avoid correspondence with litigants or others about pending, impending, or determined matters. The communication also risks violating Article 51, which guarantees a fair hearing before an independent and impartial tribunal, and the advocate's duty under the Advocates Practice Rules and the LSK Code of Standards of Professional and Ethical Conduct. Counsel should not privately attempt to influence a JO. The legal correctness of the injunction does not cure the process. Justice must both be done and appear to be done. The objective question is whether a fair-minded and informed observer would reasonably apprehend bias. In R versus Sussex Justices ex parte McCarthy, Philip K. Tunoy and another versus JSC and another 2016, and Kalpana Rawal versus Judicial Service Commission and two others. Take note that these are landmark decisions that are even provided in the course outline in professional ethics. So for you to understand everything to do with bias, you have to really read these landmark decisions before your screens. So the judge should disclose the communications of the record, hear the parties on any recusal request, and consider recusal under Regulation 21. The affected party may seek review, setting aside or appeal, depending on the procedural law. A complaint may also be lodged under Regulation 78(2). The Cabinet Secretary or Advocate may face separate contempt, professional disciplinary, or criminal consequences if the evidence establishes unlawful interference. And this brings me to another question that I'll pose before you. At one given time, I appeared in a session, it was public proceedings, where one advocate had filed a recusal application, while the other advocate had filed an application challenging the jurisdiction of the court. In your view, between those two kind of applications, which application should be heard first? And to give you context, the advocate who filed the recusal application is saying, even the application to hear whether the court will have jurisdiction can be decided impartially. And the other advocate, on the other hand, is saying, we all know about the motor vessel Lillian S. decision. Without jurisdiction, the court should not move even an inch, but it should learn its tools even to hear the recusal application. I saw that discussion in real time, and even I know the answer of what the JO said. I would like to hear your arguments. Which side will you have fallen for? Will you have listened to the recusal application, or will you have said you don't have jurisdiction to hear that matter?
I I would have sided with the argument on the based off of the Lillian S. Matters case on jurisdiction, where without jurisdiction the court has to down its tools. Wow, I am really exhausted. Anyway, so the recusal application should take precedence so that the judge can determine whether they have jurisdiction to hear this matter or they are biased. There is issues to do with conflict of interest before proceeding with hearing the matter. Otherwise, if they don't have the judicial authority to do that, they should not proceed with the case.
That is well captured. And maybe to give more context so that we also see why the advocate had filed a recusal. He is saying that the judge, okay, he was a judge, she was a judge, had written in social media that it appears that she does not have jurisdiction in this matter. So that is what prompted this advocate to bring the recusal application on grounds that the judge had already decided via social media that she did not have jurisdiction. Will that support the allegation from the advocate that even on hearing this jurisdiction application, it can be decided impartially or with bias?
Yes, I believe that is cogent, substantive evidence to show that the judicial independence of the judge and her ability to make a sound decision is compromised. And okay, I'm mostly relying on the Bangalore principles because that is what I'm well versed with, not the regulations by the JSC. But with regards to judicial independence, still, the judicial officer, rather the judge, is refrained or should refrain themselves from making public comments that would affect the fairness or the outcome of the proceedings that is presented before them or that they expect will be presented before them. So in this case, by the fact that they have already made that comment, in the eyes of a reasonable person, that would now affect their impartiality in their decision making because they're already talking about how they don't have the jurisdiction to hear the matter. So I would say that is a valid reason for the judge to recuse themselves.
Thank you, Madam Rosa. Madam Abigail?
Yeah, I also agree. I believe the recusal application should have been, if at all he had not recused himself, the recusal application should have been had first. And so it takes precedence over that jurisdiction application because it is also supported by the constitutional principle that is under Article 50, where it says that every person has a right to have their disputes settled before a fair, independent, and impartial court. So, and in addition to that, we've seen just as how my colleague had said that the test for judicial bias is normally that it has to be weighed by a fair-minded and informed observer. So I don't think it would have been proper if he had the jurisdiction application before the recusal application.
Thank you so much, and that is the ruling that was delivered in that matter. So, of paramount importance this year, we can predict a question where the judge is in Twitter and the judge is engaging the public in expressing his thinking of an active matter. And that question was also asked on a JSC participant because he had tweeted something on Twitter. So this is how we will be predicting questions. Owing to the fact of technology, that's where we are inclining towards social media. And the incorporation of the artificial intelligence topic in the course outline, because last year's course outline did not have AI questions. So another question is on public comment, political activity, and freedom of expression. We are told that a magistrate appears on a television program and openly endorses a presidential candidate. He criticizes a pending constitutional petition challenging that candidate's eligibility and states that the petition is legally hopeless. When questioned, he relies on freedom of expression and political rights under Articles 33 and 38 of the Constitution. Political affiliation or political activities were also seen in a famous judge who was eyeing for a top position, and because of political reasons or political apprehensions, it raised a lot of public scrutiny and even public comments from the same. So in this situation now we are told there is a magistrate who is appearing on a TV program and he openly endorses a presidential candidate. He even criticizes a pending constitutional petition challenging that candidate's eligibility and said that the petition is legally hopeless. When questioned, he relies on freedom of expression and political rights under Article 33 and 38 of the Constitution. So you're supposed to analyze the public comments on the pending case, analyze the political endorsement and its effect on impartiality, and explain how the magistrate's constitutional rights are balanced against the obligations of a judicial service or a judicial office. Or should now magistrates not have, should now JOs not be subjected to their constitutional rights, and they should now wear the shoes of a JO in every situation they are attending, every function they are attending. They should never depart from the shoes of a JO. What are your comments when it comes to such kind of questions? Do JOs also have the freedom of expression? Yes, Madam Rosa.
I believe, especially when it comes to the freedom of expression and association, like joining the clubs and having all these political rights, yes, the judicial officers are entitled to that, so long as it does not conflict with their judicial functions. The other issue is that the magistrate in this question is making a public comment. Again, they're supposed to refrain themselves, especially on pending matters, as that would, again, in the eyes of a reasonable person who is well informed of, these facts, that would sway the judicial officer who is making the decision in this matter in one way or another, which ultimately also affects the judicial independence. And I'm not so sure that he's the one handling the matter, but even if it was a judicial colleague handling that matter, they're supposed to make the decision independent of, any persuasion or external influences. I think I would see it in those two aspects, so on the issue of judicial independence and also propriety. Yeah, when it comes to now conflict of interest, in as much as they have that entitlement to their constitutional rights and freedoms.
Thank you so much, Madam Rosa. Let us have a look at the marking scheme. We see what are the key takeaways that we should note. We are told that under Regulation 44.1, a JO must not comment on proceedings pending or impending before any court. That is the legal backing to support Madam Rosa's answer. Describing the petition as legally hopeless prejudges its merits and may influence public perception or place pressure on the court handling it. Regulation 44.2 permits explanations of court procedure in an official capacity, provided they do not prejudice judicial integrity or the administration of justice. The comments went far beyond procedural explanation. So another key takeaway is that These regulations have not made it a misconduct against the magistrate from appearing in the television, okay, because it is permitting him to explain the court procedure in an official capacity, but they do not prejudice judicial integrity or the administration of justice. Now, the endorsement breaches the requirements of independence, impartiality, and propriety under Regulation 34 on independence, Regulation 36 on impartiality, and Regulation 40 on propriety. A JO must avoid actual bias and conduct, giving the appearance of bias. Public political alignment may cause litigants reasonably to doubt impartiality, particularly in election or constitutional disputes involving the endorsed candidate. Articles 33 and 38 protect expression and political rights, but those rights are not absolute. Under Article 24, rights may be limited by law where the limitation is reasonable and justifiable. Article 33(3) requires every person to respect the rights and reputation of others, while Article 51, 73(2)(b), 75 and 160 demand an independent and impartial judiciary and conduct preserving confidence in state office. So we are told as a key takeaway that Article 24 will limit the rights being enjoyed on protection of expression and even political rights pursuant to Article 33 and 38 that the magistrate is trying to invoke. By accepting judicial office, the magistrate assumes proportionate restrictions necessary to preserve impartiality and public confidence. The code permits citizenship and extrajudicial activities under Regulation 42 only where they are compatible with independence and impartiality. A complaint may be filed under Regulation 78, and the officer may need to recuse herself under Regulation 47 from cases involving the candidate or political dispute. So there is the right for recusal under Regulation 47, where cases will be involving the candidate or political disputes arising from that person. Then, another question is testing on extrajudicial activities, employment, and practice of law. We are told that Magistrate Asha teaches evening classes at a university. She receives a monthly salary, runs a legal consultancy company through her sister, and privately drafts pleadings for litigants appearing in other stations. She serves on a government commission reviewing court administration and receives sitting allowances. Her court has a serious judgment backlog. A, B, and C. Identify the extrajudicial activities that may be lawfully be undertaken. Do you know any extrajudicial activity that can be lawful? If you are a judge or a magistrate and you want to have side hustles, to what extent are you permitted to engage in those extrajudicial activities? And B, analyze the consultancy, drafting of pleadings, and even remuneration. Let's say you are a judge, but you are a sharp boy and you receive various contracts. A person tells you to draft an application on various angles that can enable him to win, and it is outside your scope of employment. And you are supposed to explain how the backlog affects the ethical assessment. Will you be doing that to the detriment of your performance in clearing your backlogs? How will the backlog affect the ethical assessment in this situation? What if the magistrate was performing exceptionally well in delivery of judgments and he did not have a backlog? Will that still make the ethical concern to be arising despite him having extrajudicial activities that is giving him some extra coins? To what extent have you understood on that kind of the law or provision? Any member? Is it unlawful to have extrajudicial activities?
No, it's not unlawful to have extrajudicial activities because the judicial officers are still entitled to their rights. And with regards to other engagement that they can have, I remember things like maybe having lectures, sitting on commissions and public bodies. that are mainly concerned with anything to do with public interest, insofar as that function does not conflict with their duties as a judicial officer or impede their impartiality and judicial independence, so long as it's in furtherance of maybe like developing the legal system, such as being a lecturer or anything to do with public interest.
Thank you, Madam Rosa. Madam Abigail?
Yeah, I also agree. And in particular, I think I remember regulation 43. It highlights the involvement of other activities, but it has a proviso. It says that in as much as you're getting involved in maybe lecturing, sports, you're in that commission, the proviso is that you're not supposed to be paid. You are not supposed to be paid from those activities. And number two, you are not supposed to engage now the legal, like the active legal practice, for example, drafting of pleadings, that is expressly prohibited under Regulation 43. Yeah.
Wow, thank you. Madam Rosa and Madam Abigail, let us now subject your answers to the marking scheme. And you are told that under Regulation 43(1), a judicial officer may write, lecture, and teach on law, the legal system, and administration of justice. He can engage in arts, sports, and social activities. He can even appear at public hearings concerning legal matters. He can serve on official commissions or advisory bodies where membership is compatible with impartiality and political neutrality, and engage in other activities that do not diminish the office or interfere with judicial duties. Let us see whether the angle of income will be arising from those activities. However, Regulation 43(2) states that no salary is payable for the activities specified in that regulation. A token gift, honorarium, benefit, or allowance may be received under Regulation 43(4) if appropriate to the occasion and not reasonably perceived as intended to influence judicial duties. So, inasmuch as they cannot be paid salary, Regulation 43(4) tells us that a token gift, honorarium, benefit, or even allowance can be received, okay, if appropriate to the occasion. A regular monthly salary for teaching is therefore problematic under the express terms of the code, even though teaching itself is permissible. Official sitting allowances may be permissible if authorized by law and not a salary or improper benefit. Under Regulation 43(3), a judicial officer must not engage in consultancy or practice law by giving legal advice or drafting pleadings for litigants. Running the activity through her sister does not cure the breach. Regulation 51A treats an act done through another person as the officer's own contravention. So if the examiner tells you that I am also engaging my sister, I'm not the one doing it in my own, we are told, even if your role is limited to reviewing the draft, okay, the act done through another person as the officer's own contravention will be captured in Regulation 51A. It may also amount to prohibited gainful employment under Regulation 52 and a conflict under Regulation 46. Okay, so Regulation 52 talks about the prohibited gainful employment that the JO can be participating in. So judicial duties takes precedence over external activities under Regulation 4H because Regulation 42B requires competent, diligent, and prompt performance of judicial administrative duties. A serious judgment backlog demonstrates that the external engagements interfere with the availability, and performance. Article 159(2)B requires justice not to be delayed. ASHA should cease legal consultancy immediately, disclose relevant interest, regularize permissible teaching or official work, and prioritize pending judgments. Disciplinary action may follow under Regulation 78 and even 79. So the key takeaways that we can take from this kind of an attempt is that under Regulation 44, okay, yeah, see hapo in the other previous hapa. There is an aspect to do with extra judicial activities where it has been permitted by Regulation 43(1). but it can extend to lecturing, engagement in sports, appearing in public hearings concerning legal matters, but they should not be earning a salary. And if they are receiving a token gift, honorarium, benefit, or allowance, it may be received under Regulation 43(4). Okay, if appropriate to the occasion. And from where you are sitting, I know you have one or another invited a guest speaker who is from the judicial system, and when they are given a gift, you clearly understand that procedure. The content of the gift is usually read out to the public, and if it was in a sealed envelope or something, it is to be disclosed before the public, and it is stated one by one when it is being given out to this JO, so that the JO will receive it and insert in the envelope. That is the procedure that I've seen being applicable. So as to confine ourselves to Regulation 43(4) of this Code of Conduct for judges. Now, another question that I'll pose before you: social media and commenting on pending cases. One of the most targeted prediction for us this year, we are told Justice Muli maintains a public social media account. While hearing an election petition, she likes posts calling the petitioner dishonest, shares a political party's campaign material, and writes that some litigants should accept defeat instead of wasting judicial time. Her legal researcher unanimously posts excerpts from an undelivered draft judgment and identifies the likely outcome. Analyze Justice Muli's social media conduct. Analyze the researcher's conduct and the judge's supervisory responsibility. Discuss the appropriate procedural and disciplinary responses. So the judge liked a post and shared a political party's campaign material, and even writes in his social media post that some litigants should accept defeat instead of wasting judicial time, and this is supported by her legal researcher, and anonymously posts an excerpt from an undelivered draft judgment and identifies the likely outcome. In your view, what are the issues arising in regards to the judge's conduct, researcher's conduct, and the appropriate procedural and disciplinary response? As you also think through, I wish to tell you that we have not yet gone to tier 2 of questions, because tier 2 of the questions in a mix various now principles, in a mix various breaches. You can have impartiality, you can have social media in the same factual matrix, and it is not only involving JOs, it is also involving other people like clerks, advocates, where there is a breach of the SOPEC rule, there is a breach of the ODPP practice rule vis-a-vis the Judicial Code of Conduct. But that will be the second session, because this session was only limited to the straightforward application of the Judicial Service Code of Conduct. So as you answer out, just know these are considered as the easiest kind of questions before we go to the CLE standards. We have not yet arrived at CLE standard. This is undergraduate standard. So what can you say about social media conduct from Justice Muli and even the researcher's conduct? Any member? Okay, then you can help out yourself with the social media SOPEC rule for advocates. Let us see whether okay, for social media for judges, we can say you are not taught on social media for judges, but you are taught for advocates. What if now a question comes, testing on the tests, okay, that will be applicable against an advocate for breach of the use of social media, because that is very likely. Because a question like this one in emanate from the judge, sasa ana comment, advocate pia ana like, pia anaongeza mambo yake, and then you are told separate each one. Question A, just discuss on the judge. Question B, just discuss on the advocates. Okay, so for purposes of this discussion, let us limit ourselves first to what we have before the screens, so that we will engage the advocate code of conduct as topic rules in a situation where they are conflicting with the judicial service code of conduct. So with the silence, I will take this question as the most failed question in this session, unless a person wants to redeem themselves. Then we jump straight into the marking scheme. What do you have to comment on social media? Are judges allowed to use social media? Okay, so let us analyze Justice Muli's social media conduct. Under Regulation 12, a judge is responsible for online activity and must avoid associations or conduct that adversely reflect upon impartiality, interfere with judicial duties, or diminish the status of the office. Sharing party campaign material and endorsing disparaging posts during an election petition create a reasonable apprehension of political bias and violate Regulation 7, 9, 12, and 14, and even 15. Under Regulation 18(1), a judge must not comment on pending proceedings and must require similar abstention from court personnel under the judge's direction. The statement about litigants refusing to accept defeat may reasonably be linked to the pending petition and prejudge the matter. A judge may explain court procedure under Regulation 18(2), but must not comment on the merits. So if the judge was in a position to comment and say that it is a good procedure if you are writing submissions to be brief to the point, but not mention anything to do with any pending matter, that is allowed for the use of social media, pursuant to Regulation 18(2). But it should not comment on the merits of a decision. Okay, so refrain from pending proceedings, and the similar prohibition is also applying from a court personnel under the judge's direction. So the researcher is a judicial staff under Regulation 2. Publication of draft judgment excerpts breaches confidentiality under Regulation 61, misuse of official information under Regulation 69, and potentially unlawful access or dissemination under Regulation 76. Draft judgments are expressly within the definition of confidential information in Regulation number 2. So the researcher's anonymity does not excuse the breach. So the researcher has breached all those provisions. He has published a draft judgment excerpt that has breached confidentiality under Regulation 61. It is amounting to a misuse of official information under Regulation 69, and it is potentially unlawful. It is potentially unlawfully giving access or disseminating information under Regulation 76, and draft judgments are expressly within the definition of confidential information in Regulation number 2. The judge's responsibility depends on knowledge and reasonable preventive steps. Regulation 30 prohibits a judge from causing or directing another person to breach the code or knowingly permitting a subordinate to do so. It does not impose strict liability for an unauthorized act where the judge lacked knowledge and took reasonable steps to prevent it. The judge should disclose the relevant posts, preserve evidence, and hear any recusal application under Regulation 21. The parties may seek recusal, review, or appeal under applicable procedural law. The JSC may investigate complaints under Regulation 78 to 81, and the researcher may face disciplinary proceedings under Regulation 79, employment sanctions, and possible liability under the Computer Misuse and Cybercrimes Act if unlawful access or disclosure is established. So that can also amount to a criminal offense on disclosing confidential information that is under the public custody of state office. Question 4 is on integrity, gifts, bribery, and future benefits. Also a potential area because we saw a magistrate this year and a probation officer being arrested on allegations of bribery and future benefits to give certain orders in future. During a complex tax case, the taxpayer's director sends Magistrate Tendo an expensive watch as a birthday gift. The director later offers the magistrate a position as head of legal affairs after retirement. The magistrate returns the watch but says nothing about the job offer. His spouse accepts a discounted holiday from the taxpayer. There is no evidence that his judgment was actually influenced. Analyze the watch, job offer, and holiday under the code. Explain the distinction between an impermissible benefit and a permissible token gift or honorarium. State the disclosure, recusal, and enforcement steps required. Hapa sasa ndio maswali sasa zimeanza kuwa za CLE kwa umbali. Unaambiwa yeye alikataa lakini bibi yake akachukua holiday. Ama the husband akaamua siwezi wacha hii holiday. Alafu akarudisha ile watch alipatiwa. Lakini juu aliona manzi akiretire hakuna kazi atakuwa nayo na ameambiwa kuna job offer ya kukuwa legal affairs head. Okay, akasema hiyo wacha ni nyamaze. How should then the conduct be expecting the judge to have talked about the future legal position? Kwani code of conduct inaweza kuwa na another avenue. What about the distinction between impermissible benefit and a permissible token gift? How will I know that this is impermissible and this is permissible? To what extent? Okay. And what are the disclosure, recusal, and enforcement steps required? Any member here mwenye anaweza kuwa na answers atusaidie. Kwanza kukimbilia hiyo holiday. Nani? At second person. Mwenye maybe hata you don't have knowledge maybe alienda. What can you say about that? Any member, you can discuss your ethical concerns. Yani generally, si lazima ukue direct to the marking scheme. What are your ethical concerns in this kind of situation? Kurudisha hiyo saa kama angechukua. Any attempt. Sema sasa swali imekuja mandatory professional ethics. Wewe umejipanga na Advocates Act, SOPEC rules, umeshika rule by rule, section by section. Lakini sasa question number 1 inakuweka chini kwanza. And I've said these are the simplest question. We have not disclosed question tier 2. Hii usiwache ikupite. What will you say? These are impermissible benefits. These are permissible benefits. I can take this holiday. I cannot take this holiday. Or nor my wife or husband. Should I return the gift? Is that sufficient? Okay. This is also proving that Judicial Service Code of Conduct and Ethics iko na difficult questions ni venye students hawajajua how to extract such kind of questions from this document. Under Regulation 38(2), a judicial officer must not accept gifts, loans, bequests, benefits, or things of value where acceptance is prohibited or appear to undermine independence, integrity, and even impartiality. Regulation 45(3)-4 prohibits a JO or family member from directly or indirectly negotiating or accepting remuneration, loans, gifts, advantages, privilege, hospitality, or favors that are incompatible with office, reasonably appear intended to influence judicial activities or duties or reward their performance. So the code imekuwa direct to the point. You should not accept gifts, loans, bequests, benefits, or things of value where acceptance is prohibited or appear to undermine independence, integrity, or impartiality. Who are the person giving out this loan or watch? During a complex tax case, the taxpayer's director, okay? So it is already from a prohibited scenario that will create an impartiality, will undermine independence and even integrity. And we are told by Regulation 45, look, even if it is a family member, either direct or indirectly, you accepted remuneration, you engaged in negotiation, you received a loan, a gift, an advantage, a privilege, hospitality, or favor. So in this situation, there was a favor being advanced and reasonably appear intended to influence judicial duties or even reward their performance, will land the judge in trouble. The expensive watch came from a litigant in a pending case and was plainly improper. Returning it was necessary, but did not discharge the duty to disclose and address the attempted influence. So one thing we can say is that returning gifts merely without disclosing, okay, without discharging the duty to disclose and address the attempted influence, the code haitaki hiyo story. You must disclose, okay? The spouse's discounted holiday is an indirect family benefit covered by Regulation 45. Actual influence need not be proved because reasonable perception will be sufficient. About the future employment offer, this creates a conflict and possible attempted influence. Although Regulation 19 expressly governs offers of future benefits to judges, the JO provisions on integrity, propriety, conflict, and bribery, pursuant to Regulation 38, 40, 45, and 46, produce the same results. The officer should disclose the offer to the chief registrar and refrain from the case. The conduct also engages Article 73(2)(b), 75, and 76 of the Constitution, the Anti-Corruption and Economic Crimes Act, and the Bribery Act of 2016. Under Regulation 43(4), a JO may receive a token gift, award, honorarium, benefit, or allowance appropriate to an occasion only where it will not reasonably be perceived as intended to influence judicial duties. So it is not prohibited in totality against a judge from receiving a gift, an award, an honorarium, a benefit, or even allowance where it is limited to an occasion where the perception of bias will not be forthcoming. So the source, timing, value, relationship to pending cases, and public's perception are decisive. An expensive litigant funded watch or holiday is not a permissible token. The magistrate should place the approaches on record, disclose them to the chief registrar or JSC, and consider recusal under Regulation 47. The attempted benefit should be reported to the EACC Commission where corruption is reasonably suspected. A complaint may be lodged under Regulation 78(2), and a breach is misconduct under Regulation 79. The absence of proof that the judgment was influenced does not extinguish the ethical breach. And one ethical test that the JSC Commission was testing on from candidates, ulikuwa unaulizwa, let's say you are in a bench and then you discover that one of the bench person receive a corruption allegation, receive a bribe. What are you supposed to do? So if you do a recusal application from that bench, automatically bado huja comply na code of conduct. Code of conduct inasema you withdraw, you do an application to the Chief Justice maybe to recuse yourself from that bench, alafu inataka una disclose hii maneno, unaambia the relevant agencies na even you address it to the Chief Justice. So code of conduct inataka ukue a whistleblower so that you don't stay with irrelevant information that could have assisted investigations from continuing on. So that is the key takeaway yenye nilikuwa nataka mwanze kuona wakati unajibu swali to do with judges, automatically ukikimbilia kujirecuse, don't think you have dispensed away with the duty of disclosure. Then tutapiga hii swali ya question 3 on recusal, conflict of interest and necessity. And then due to time tutaangalia trial advocacy for people who want to remain to the session, ama in the alternative mnataka tuendelee hadi we finish up at 6 am. I'm bound by your decision. What do you want to suggest kwanza before I even read out the question number 3? What do you suggest? I continue with this session or we break to trial advocacy? Any member? Do you want us to continue with the session all the way to 6 am? Or you want me to break the session to trial advocacy?
We can proceed with this one.
Okay, that is well captured. Any other objection? Kama hakuna, I'm bound by that. So question number 3, it is testing on recusal, conflict of interest and necessity. And we are told that Justice Njeri is assigned a commercial appeal involving a company in which her husband owns 12% of the shares. Her daughter is employed by the company as finance director. Justice Njeri discloses that she attended university with the managing director, but insists she can remain impartial. She declines to recuse herself because the station has only one other judge, who is on leave. The matter concerns an urgent application to preserve assets from removal outside Kenya. Now, distinguish between actual buyers, apparent buyers, and conflict of interest. Then B, apply the recusal provisions to the fact and explain the required procedure. And C, discuss whether necessity or urgency may permit Justice Njeri to act. How will you deal with the necessity to sit vis-a-vis a conflict of interest that is eminent in that dispute? So the floor is yours. We told there is a judge. He has a commercial appeal and in a company where her husband owns 12% of the shares. Her daughter is employed in that company. He even discloses that she attended university with the managing director, but insists she can remain impartial. And she declines to recuse herself because on necessity or duty to sit. This was tested in a landmark decision this year, where the judges refused an application from one Raphael Tuju on recusal on grounds of necessity and duty to sit. This was also tested in the Supreme Court decision BBI. We have also seen allegations on bias emanating from the Court of Appeal by Rigathi Gachagua. So, what can you say in these situations? member, you can borrow your knowledge from the conflict of interest that is applicable in the advocate side, so that we clearly hear out whether you have some basic knowledge. It appears to be technical to you members. So let us go direct to the marking scheme so that we appreciate the question before our screens. So the examiner is expecting to hear from you that actual bias is demonstrated, prejudice or predisposition against a party. Okay, so actual bias is demonstrated, while apparent bias arises where a fair-minded and informed observer, having considered the facts, would reasonably apprehend that the decision maker may not be impartial. A conflict of interest arises where a judge's personal, family, financial, or fiduciary interest conflicts or appears to be conflicting with his official duties. Okay, so a conflict of interest iko na other aspect of judge's personal or family or financial or fiduciary interest. Under Regulation 21, a judge must use best efforts to avoid actual or apparent conflicts. Regulation 21 identifies circumstances for recusal, including being a party or material witness, personal knowledge of disputed facts, actual bias, personal interest, a relationship with a person interested in the outcome, prior participation as counsel, any other sufficient reason, or an economic interest held by the judge or a family member. This is the same Regulation 20 that criticized the applicant in the JSC who had a prior participation as counsel on behalf of a prominent person. So we are told that Regulation 21 identify the circumstances for recusal, because next time CLE will tell you kindly give various circumstances for recusal of a judge. Okay, and the answer will be being a party or material witness. There is personal knowledge of disputed facts that you have. There is actual bias. There is personal interest. There is a relationship with a party or a person interested in the outcome. There is prior participation as counsel and any other sufficient reason, or even an economic interest held by the judge or a family member, like in this factual matrix. So you are told by Regulation 21, a judge must use best efforts to avoid either actual, that is demonstrated, or apparent conflict before the eyes of a fair-minded and informed observer. So the husband's significant shareholding and the daughter's senior employment create an objective appearance of partiality and a family economic interest under Regulation 21E and H. The university association alone may be insufficient, but it adds context. Justice Njeri should disclose all material facts and recuse herself. Under Regulation 21(2), the specific reasons must be recorded in writing as part of the proceedings. The constitutional basis lies in Article 50, 1, 73(2)(b), and 75. The applicable test was discussed in Philip K. Tunoi versus JSC in 2016, where the apprehension must be reasonable and held by a reasonable, informed person. Recusal should not be granted on fanciful suspicion, as emphasized in Kaplana H. Rawal versus JSC in 2016, but direct familial financial interests are very substantial. In Regulation 21(3), it recognizes about necessity. So a judge may decline recusal where no other judge can deal with the case, where urgent circumstances mean failure to act could cause a serious miscarriage of justice, or where a plural bench has rejected the recusal application. Justice Jerry may make only strict necessary interim preservatory orders if delay would defeat justice and no alternative judge can act. She should disclose the conflict, hear the parties, give reasons, tailor the order narrowly and arrange transfer or inter-parties consideration by an unconflicted judge as soon as possible. Necessity is exceptional. It does not justify her final determination of the appeal. So, when you are answering questions to do with conflicting scenarios between necessity and the duty to recuse yourself, we are guided by regulation 21.3 that tells us at times it can be exceptional where there is no other judge or unanimous decision of the bench to sit and hear that matter. So, and the level of participation will be for the preservation of the interim reliefs, then not engaging yourself in the detailed application or merits of that matter. Question 13 is on judgment delivery, alteration of records, and file custody. A judge delivers an oral judgment in open court without a written text. 2 days later, she prepares written reasons that materially differ from what she said. She directs the court assistant to alter the transcript and keeps the physical file at home for 3 weeks after delivery, claiming that she intends to perfect the record. Analyze the oral decision. Analyze the letter alteration or reasons and transcript. Analyze the file custody and identify available corrective and disciplinary measures. Remember, this is the direct also merit to Gachagwa's appeal, where he's saying that the oral pronouncement of the judgment is very different from what was written because there are some paragraphs being omitted in the final paper. We'll not discuss into the merits because we understand about sub judice, but this is also a potential area that CLE can also target to see whether you understand what we call the code of conduct for judges and whether that is really permissible in such circumstances. What are your thoughts? Members, what are your thoughts when it comes to oral decisions and letter alterations of reasons and transcript? What is the code of conduct saying when it comes to such kind of activities? Okay, due to time and the complex status of the case, let us see the marking scheme. Under Regulation 11.2a, a judge must not deliver an oral decision. The rule requires a formal written decision, preserving clarity, accountability, and an accurate appellate record. Under Regulation 11.2b, a judge must not alter the substance of reasons already given, the transcript of evidence, or the summing up. Correcting a clerical or accidental error in accordance with the lawful review or slip rule procedure may be permissible, but materially changing the reasoning after delivery is prohibited. Directing the assistant to alter the transcript also violates Regulation 30. Since the judge causes another person to commit a breach, the court assistant will separately violate Regulation 59.6 by altering or falsifying a record unless acting under a lawful court order and may breach Regulation 77. So this is to tell us that Regulation 59.6 will not spare the court assistant because in his own capacity he is also altering or falsifying a record. So materially false alterations may implicate the penal code and offences concerning judicial or public records. Under Regulation 11.2c, after delivering a decision, a judge must not retain a court file for more than 24 hours unless written law permits it. Keeping it at home for 3 weeks is a breach. It also risks loss, interference and denial of access, contrary to the duty to preserve court process integrity under Regulation 8 and public property under Regulation 24. So the file should be returned immediately, the original transcript and audio secured, and all alterations transparently disclosed. A party may seek correction under the applicable procedural law, review, setting aside or appeal. A complaint may be made under Regulation 78(2). So deliberate alterations of reasons and records is serious misconduct under Regulation 79 and we engage Article 168. So key takeaways when dealing with such approaches. We were told that Regulation 11(2), a judge must not deliver an oral decision. But what we see in practice is because judges are aware that under Regulation 11(2)(c), after delivering a decision, I have 24 hours to issue written judgment and upload the same in the CTS. So there is an exception to that effect. But we are also told that under Regulation 8, there is a duty to preserve court process integrity and public property under Regulation 24. So going with the file and staying with it in your home for more than 3 weeks will amount to the breach of public property under Regulation 24. And also remember Regulation 24 is also applicable to vehicles used in the court station, being public property, where you will be using a vehicle that is allocated by the state to go to your personal events that is not in conformity with the judicial position. Then you have also seen where the judge is trying to direct an assistant to alter the transcript. Remember we said Regulation 30 is where you are using a person under your orders or your supervision to do something unlawful. So even if they engage in such activities, therefore the assistant will not be spared, even in his own capacity under Regulation 59(6), by altering or falsifying a record unless acting under a lawful court order and may breach Regulation 77. So even if the judge sends an assistant to collect a bribe and there is a written documentation or instruction to do that, automatically the judge will not be spared because it will be taken as if they were in a cooperating arrangement. That happened in the course of the week where a clerk was arrested in Kisii side, Busia, where he was taking out a bribe. So we have a question to do with tenders, shares, public collections, and foreign accounts. We have judges who are investors, who participate in money market, who know about the rule of trade. So the code of conduct will not spare them in one way or another. And you are told that Justice Otieno owns 40% of Supply Company Limited and is one of its directors. Supply Company tenders to provide computers to the judiciary. He also opens a bank account in Dubai without JSC approval and organizes a public fundraiser to build a private school owned by his family trust. He argues that the company and trust are separate legal persons from his personal identity. Now, analyze the tender participation, analyze the foreign bank account, and analyze the fundraiser and the reliance on separate legal personality. Are judges allowed to participate in tenders? Are judges allowed to own separate foreign bank accounts? And are judges allowed to call for fundraisers from the public? Any answers? Remember about the event that happened this year where a judge invited his friends in his or her capacity as a human being, and these people showed up. What if he had invited these people for a fundraiser? Okay, maybe we are told that by the examiner, after securing her position as the JSC officer, the judge was under a financial critical condition and he used this opportunity to also hall for fundraising, but it was not in record. What will the code of conduct say on fundraising? And that will inform you why judges are prohibited from calling for harambees. Any attempt because of time? Ringera, you had unmuted.
Let me take a trial. So on public collections, the judge is prohibited by the Judicial Service Code of Conduct and Ethics from soliciting contributions unless leave has been granted by the president through a notice in the Gazette. So in this particular fact pattern, then we the public collections cannot be construed to apply here because this is a separate entity that is looking to raise funds, the school. For participation in tenders, we find that for participation in tenders, we find that the code is deterring judges from participating in tenders or owning shares in a company that supplies material to the judiciary. So for supply tender company supplying to the judiciary, then that is a clear violation. Then my other trial is the bank account outside Kenya. So judges are prohibited by the code and the constitution from opening accounts outside Kenya without the approval of the Judicial Service Commission.
Thank you, Ringera. Let us see whether you will have scored some marks in that question. So the marking scheme says on tender participation, Justice Otieno has breached Regulation 23 of the JSC Code of Conduct and Ethics, Regulations of 2020. That provision prohibits a judge from participating directly or indirectly in a tender for the supply of goods or services to the judiciary or the JSC Commission. Although ordinary shareholding does not without more amount to participation, that protection does not apply where the judge has a controlling shareholding or is a director of the tendering company. Justice Otieno owns 40% of Supply Co. and more decisively is one of its directors. He therefore falls within the express statutory exception and is treated as participating in the tender. That is Regulation 23. The tender also creates an actual or apparent conflict between his private financial interest and judicial office, contrary to Regulation 21. So another aspect is on financial interest vis-a-vis the judicial office that he is occupying, pursuant to Regulation 21. He must avoid circumstances in which his personal interests conflict or appear to conflict with his official duties. Although Regulation 22 permits a judge to hold shares, it does so only where the interest does not compromise performance of judicial duties. So don't be misconceived that judges should not be shareholders in different companies. They can, and they do so only where the interest does not compromise performance of judicial duties. He cannot rely on that permission where his company seeks a public contract from the institution in which he serves. That is the exception. The conduct further breaches Regulation 14G.
which permits lending the prestige of judicial office to advance private interest and implicates Article 73(2)(b), 75, 227 of the Constitution, because Article 227 of the Constitution requires public procurement to be fair, equitable, transparent, competitive, and even cost-effective. Supply Company Limited should withdraw from the tender, or Justice Otieno must divest or resign from the directorship before any future procurement, subject to the procurement and conflict rules. He should make full disclosure to the JSC and the relevant procurement entity and take no part directly or indirectly in the process. What is the law saying about a judge having or a judicial officer having foreign bank accounts? Justice Otieno's Dubai account contravenes Regulation 25(1), which, subject to Article 76(2)(a) of the Constitution, prohibits a judge from opening or continuing to operate a bank account outside Kenya without JSC approval. So directly, under Regulation 25(1), you will require JSC approval for you to continue to operate a bank account outside Kenya. Under Regulation 25(2), a judge with reasonable grounds for opening or maintaining a foreign account must apply to the JSC through the Office of the Chief Justice. He did not do so. The fact that the account may be lawfully under Dubai law does not satisfy the Kenyan constitutional and ethical requirement. If approval is granted, Regulation 25(3) requires the Justice Otieno to do the following: to submit annual account statements to JSC and authorize the JSC to verify the statements and other relevant information directly with the foreign financial institution. Article 76(2)(a) similarly restricts a state officer from maintaining a bank account outside Kenya except in accordance with an Act of Parliament. The relevant statutory framework includes Section 19 of the Leadership and Integrity Act, which governs approval of foreign accounts by state officers. Justice Otieno should immediately disclose the account, explain why it was open, apply for approval if he has reasonable grounds, and comply with all disclosure and verification requirements. If approval is refused, he should close the account and provide evidence of closure. The unauthorized opening or continued operation amounts to misconduct under Regulation 79 and may trigger disciplinary hearings. Before we go to fundraising, let us repeat on the various aspects of why you should not have a foreign bank account and what are the requirements. You are prohibited from opening a foreign account without GSC approval directly by Regulation 25. And in Regulation 25(2), the judge with reasonable grounds for opening or maintaining a foreign account must apply to JSC through the Office of the Chief Justice. And we are further told by Regulation 25(3) that you submit annual account statements to the JSC if that application is allowed, and you authorize the JSC to verify the statements and other relevant information directly with the foreign financial institutions. This is where we now extract various provisions of other laws that talks about foreign accounts, because Article 76(2)(a) of the Constitution places a restriction against a state officer from maintaining a bank account outside Kenya except in accordance with an Act of Parliament, and the relevant statutory framework includes Section 19 of the Leadership and Integrity Act, which governs approval of foreign accounts by state officers. So luckily, we also have other provisions to support our answer apart from Regulation 25(3) and 1 or 2 of the Judicial Service Code of Ethics and Code of Conduct and Ethics. So automatically now we know the procedure when we have foreign accounts. What about fundraising and separate legal personality? Justice Otieno's organization of a public fundraiser for a private school owned by his family trust is ethically improper. Under Regulation 22(1), a judge must not solicit public contributions for a public purpose unless the President has, by Gazette notice, declared a national disaster and authorized a public collection for that purpose. This is where Ngera could have scored marks when attempting that question. Building a private family-owned school is neither the authorized response to a national disaster nor on the facts a qualifying public collection. Under Regulation 22(2), a judge must not participate in public fundraising in a way that reflects adversely on integrity or impartiality or even interferes with judicial duties. Regulation 22(3) permits participation in voluntary fundraising only if it does not adversely affect integrity or compromise judicial duties. This exception does not protect Justice Otieno because he is organizing and soliciting funds for an undertaking connected to his family trust and therefore has a direct or indirect private interest. Take note that Regulation 22(3) permits participation in voluntary fundraising only if it does not adversely affect integrity or compromise judicial duties. So, under Regulation 22(2), we are told that a judge must not participate in public fundraising in a way that reflects adversely on integrity or impartiality or interferes with judicial duties. So it is not a blanket rule that a judge should not engage in voluntary fundraising activities. They can participate in Harambes, but they cannot call Harambes for their own benefit without the approval of the president in a gazette notice on grounds of a disaster, national disaster, or a qualifying public correction reason. But in his own volition, he can attend these voluntary ones provided or the factual matrix or the situation is not adversely affecting integrity or compromising his judicial duties. So his conduct also breaches the following regulations. It is breaching Regulation 14(1) by lending the prestige of judicial office to advance private interest. Regulation 14(3), which requires private affairs to be conducted in a manner preserving public confidence. Regulation 20, because the family trust creates an actual or apparent conflict of interest, and Article 75(1) of the Constitution, which prohibits conduct creating a conflict between personal interest and public duties, compromising public confidence or demeaning the office. So the separate legal personality argument does not excuse the conduct. While supply company is legally distinct from its shareholders under the rule in Solomon versus Solomon, the code expressly regulates both direct and indirect participation. Regulation 23 specifically looks beyond the corporate form, where the judge has a controlling shareholding or is a director. Similarly, a trust legal structure does not eliminate the judge's family connection, fiduciary interest, or potential benefit. Fiduciary interest under Regulation 2 expressly includes a relationship associated with a trustee. Regulation 14(1)(h) also generally prohibits a judge from serving as a trustee or assuming another fiduciary responsibility except for a family estate, trust, or person, and only where it does not interfere with judicial duties. So they are prohibited, but they are allowed to serve as a trustee in family estate and trust or person. Even if his trusteeship of the family trust were permissible, it will not authorize him to use judicial prestige pursuant to Regulation 14 to obtain public funds for it. Further, Regulation 31(a) prevents a judge from evading the code by acting through another person. He will remain responsible if the fundraising were conducted through the company, trust, relatives, or even agents on his behalf. Justice Otieno should stop the collection, disclose the funds raised and his interest in the school, account fully to the contributors, and return contributions where appropriate. The matter may be referred to the JSC under Regulation 78(2). By Regulation 79, breach of the code amounts to misconduct and may also engage the Leadership and Integrity Act. Regulation 79 is an equivalent Section 60 of the Advocates Act because Section 60 is the umbrella provision of professional misconduct for advocates, but Regulation 79 is the umbrella provision for misconduct against JO and judges. So also take note of the Public Officer Ethics Act, anti-corruption laws, and depending on handling of funds, criminal or civil liability. This will mark the end of the first segment of the analysis of this Judicial Service Code of Conduct and Ethics. I'm also doing Bangalore Principles analysis, questions and answers that can emanate from that document. And if you are also keen, I've also shared a certain documentation in the group that tells us on the various advancement of the probate law. Okay, so I'm also planning on how I will have a webinar on that document because it is very well detailed and very relevant to the current market. It advances various doctrines that have been, they actually made petition this year, in fact last week. So we can't we can't afford to ignore such publication that is emanating directly from our seniors. So unless there are comments or even feedbacks, that will be greatly appreciated. Don't miss out on part B of this session. Any feedback, comment? Okay, if there is none, I officially end the session, and let's meet in the evening over the discussion of some of the past papers. So thank you so much as I seek to have an analysis of this family bench book. Remember, we were doing an analysis of the criminal judicial bench book. We did the same. The recording is available in our YouTube channel, where we went to the extent of realizing various procedures that are hidden from the common law reading. So this book appears, it is known as Family Law Bench Book, volume number 1. It is touching on statutory provisions, leading authorities, areas for reform. The date of publication is 2026, the year of publication. The exact date is missing, but it appears to be a very new document. So if you are reading PDFs that were created in the year 2015, 2016, and you happen to encounter such kind of publications that are very relevant, then automatically just know your fate is being cooked. Fate is being cooked. So they have even written the purpose of the book, and CLE pia imewafikia hii kitabu, and we were told that in formulation of questions, the JSC or judges are also given a room for them to create various questions. So what makes you think that this kind of document haijawafikia? So it is very relevant for probate. That's why we will have to do a dissection of this document, and by dissection I even incorporate drafting aspects, yani isikuwe tunasoma theory peke yake. So let us meet in the evening for past papers. So okay, I'll have a look at the papers. Nimeangalia, we started with probate 2026. We only managed to do one question. There is a possibility we can proceed with 2026 paper, or a possibility that we can also continue with the 2023 paper, then decide on a unit. Okay, so let us call it a day as we endeavor to do more research. So thank you so much. The meeting is officially closed.